Hey folks, I'm Mark from the Four Boxes Diner. Okay, we just had oral argument in the biggest Second Amendment case in over a decade. That's the New York State Rifle and Pistol Association versus Bruin, okay? I have a very long video that analyzes and provides you with a complete analysis of everything that went on at that oral argument in great detail. But it's a longer video, so if you really want to know the details, check that out. But this video here is going to be a quick video just to give you 5 highlights for you to take away. And again, if you want more analysis, check out the much longer video if you really want more detail. Okay, so the bottom line is this. In the case of Nyserpa versus Bruin, involving whether or not you have a right under the Second Amendment to carry a gun outside the home in public, there was an oral argument. Remember, there are 9 Supreme Court justices on the Supreme Court. To win a case, you need to win 5 justices. So the way we look at the Supreme Court is, do the gun rights plaintiffs who are challenging New York's law, do they or do they not have 5 votes to basically strike down New York's law as unconstitutional under the Second Amendment? And based on the oral argument and my general understanding of what's been going on with the Second Amendment and the Supreme Court, I'm happy to report that the answer looks to be yes. Odds are there are 5 and possibly even 6 votes to strike down the New York law under the Second Amendment as being unconstitutional. Here are my 5 takeaways as to why I think that's true based on what happened at the oral argument. First, while the parties, both New York and the plaintiffs, meaning the lawyers for the gun rights advocates, they both seem to agree that history, I repeat, history of the Second Amendment along with the text of the Second Amendment is key. Based on the Supreme Court's 2008 decision in Heller, the oral argument basically had very little discussion during it about what was the history and the founding era of the United States around 1791 when the Second Amendment was ratified. The more consequential debate between New York and the gun rights advocates, if you will, was over which, I repeat, which set of history would apply to this Second Amendment case. The United States government and New York basically pressed the court and argued to the court that the relevant history should extend into, ready for this folks, the late 19th century and the early 20th century, going all the way up and through the 1911 Sullivan Law in New York. They basically were arguing that American history, when it comes to the Second Amendment, that should be considered in understanding the text of the Second Amendment, should run all the way from 1791 all the way into the 20th century, and basically any isolated law that's a gun control law that was upheld would be viewed relevant to understand the original meaning of the Second Amendment. Of course, the gun rights position, the plaintiffs argued that you should focus essentially on 1791 or so, and I suspect that at the end of the day, the Supreme Court is going to, like they did in Heller, focus on the relevant history in the year 1791 when the Second Amendment was ratified and not extend their analysis into the 20th century. So that's the first takeaway to keep in mind. The second takeaway that I want to bring to your attention is that, and this is very good news for the Second Amendment, none of the key justices that I think the gun rights advocates have to win, that's Justice Roberts, Justice Kavanaugh, or Justice Amy Coney Barrett, none of them expressed any support, as best I could tell, for changing what's called the standard of review, or the criteria for assessing whether or not a gun control law violates the Second Amendment. Because right now, the rule of law, or the standard, is set forth by the Heller case in 2008, and in that case, the Supreme Court set a clear standard of review, which is basically you figure out whether or not a gun law violates the Second Amendment by looking at the text of the Second Amendment, by looking at the history of the Second Amendment, and by looking at the tradition of Second Amendment rights and gun rights in America's founding period, okay? Now, the anti-gunners in New York have largely been arguing for many years now that there should be a different standard of review, a standard of review called tiers of scrutiny or interest balancing tests, whereby even if there's a violation of the Second Amendment by a gun control law, that law is allowed to stand if the government can show there's a really important public safety interest being advanced there. And of course, that's a very bad standard for gun rights advocates and a very good one for people that support government gun control. But the good news is it looks like probably 5, if not 6 justices on the Supreme Court are going to reject this interest balancing test as applied to the Second Amendment, which is very good news for Second Amendment proponents, okay? And I want to say that because all of Justices Roberts, Barrett, and Kavanaugh simply did not seem to be buying into the notion that you could balance away constitutional rights for the Second Amendment, or frankly, really for almost any other right, as they mentioned it at oral argument, okay? Now, the third takeaway, the third quick takeaway I want to mention is that public safety was a recurrent theme at the oral argument. Now, again, that's because the New York State government really needed to convince the court to use a standard of review other than text, history, and tradition, because again, under text, history, and tradition, I think it's going to be very hard for New York to be able to show that their existing carry regime, which is really a no carry regime, is consistent with the Second Amendment. The lawyer arguing for New York repeatedly stressed the need to keep guns off the streets of densely populated areas, presumably cities. She expressed less concern for carrying guns in the more rural parts of the state, but the truth is she got a lot of pushback on this distinction from both Chief Justice Roberts and Justice Alito, both of whom suggested that the need for self-defense might actually be greater in the more concentrated high crime areas of the state rather than the rural areas. But again, if the court adopts what they did in Heller, the text, history, and tradition approach, then the public safety arguments are essentially going to be irrelevant. But if it applies tiers of scrutiny, they will become front and center, but again, right now it doesn't look like that's going to be happening. The fourth takeaway from the Bruen oral argument was a discussion of something that I think is actually a very dangerous concept for gun rights proponents, and we need to watch this carefully, because this is how they're going to take away your gun rights and use an exception potentially to swallow the Second Amendment rules. Watch this very carefully and know this is very important. And that is a discussion of gun-free zones, or as the Supreme Court called it, sensitive places. I repeat, sensitive places. Because in the Heller decision in 2008, they said that it's presumptively constitutional to ban guns in certain quote-unquote sensitive places such as schools and government buildings. Now, that one paragraph in Heller that blessed these gun bans in sensitive places was in what's called dicta, but basically they indicated they would sign off on such things. And today, all the justices seemed on board with the concept, the general concept, that there can be sensitive places where you could ban guns, like government buildings and maybe certain schools. But they didn't really figure out the context, and they weren't even sure they needed to, because Justice Kavanaugh said at oral argument that the truth is we don't need to decide the scope of sensitive places. In this case, we just need to decide whether or not the plaintiffs that want their ability to carry guns in New York should be entitled to carry guns in New York under the Second Amendment, and they can set aside and talk about sensitive places at another time. But I suspect we will see a discussion of sensitive places in this case, and we need to watch that very carefully, because you could easily see a situation where states could claim that the vast majority of the state is a quote-unquote sensitive places where they can ban guns, and of course that would render irrelevant your Second Amendment rights in those places. Again, I don't think the Supreme Court would go that far, but we got to watch out for that sensitive place exception, which I call the gun-free zone exception to the right to carry guns outside the home. Okay, and finally, my fifth takeaway from the Bruen oral argument. Again, as I said elsewhere, I have a very long, detailed analysis of the entire argument, but it lasts for, like 30 minutes or so, and you're welcome to watch that. That's great if you do, but I'm trying to give you the hot takeaways here, so you at least get the essence of what went on here, and you don't have to try to filter it through perhaps maybe some of the liberal mainstream media that isn't going to get it right, what's really going on. Okay, so the fifth and final takeaway from the oral argument in Bruen is that there's a debate about whether or not the Second Amendment is actually a normal constitutional right like the other constitutional rights in the Bill of Rights. Now that seems like an absurd question, right? Of course the Second Amendment is on par with the other constitutional rights in the Bill of Rights, but there was a real debate about this because New York, I repeat, New York argued that the right to bear arms under the Second Amendment is allowed to apply differently in, let's say, the cities versus the countryside. And basically they said that government should be receiving and have a lot more discretion as to how they apply the Second Amendment based on what's good for local public policy. But the good news is that even liberal Justice Elena Kagan, who's no friend of the Second Amendment, I would say she's generally anti-Second Amendment. I think everyone would agree with me on that. Even she seemed to indicate that the New York argument on this point was not typically how we treat constitutional rights. The rule is everyone in America has a constitutional right to a particular issue. You don't have to go to the government, some licensing agency, and ask Mother, may I, can I have my constitutional right? That's generally not how constitutional rights work. Even Elena Kagan, the liberal on the court, one of the liberals on the court, even wasn't really seemed to be buying into the New York argument. And of course, both Justice John Roberts and Justice Kavanaugh also pushed back on this point, saying, well, how can you really say the Second Amendment should not be equally enforced with the other aspects of the Bill of Rights? Okay, so to wrap up, I gave you a quick summary here. We'll be talking a lot more about what happened in the Bruen oral argument and what it might mean for your rights going on, but I wanted to give you this quick summary right now. We should expect a decision in this case somewhere between now and the end of June 2022, probably the end of June of 2022, because that's when the Supreme Court releases their big high-profile case opinions, and this will undeniably be one of the high-profile decisions of this term. And again, if you are interested in a more in-depth discussion of what happened at oral argument, I have, again, the other video that you can watch that gives you a little bit more of the play-by-play, but again, it's much longer. So, okay, well, thanks for joining me again here at the Four Boxes Diner, where we serve hot, fresh, Second Amendment news and analysis. And if you like what you heard, then please subscribe. I'd really appreciate it, and to help us spread the word. So, again, we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.